Welcome back to CEO Money. I'm Michael Yorba, your host. Thanks for joining us. Michael Brette, the president and CEO of VentureNet Capital Group, small cap equity advisors, is on the show with us. Michael, welcome back.
Thank you. Appreciate it.
Yeah, my pleasure. You advise clients on a worldwide variety of transactional business matters, from startup, consulting, capital introductions, business valuations, reverse mergers, Reg A plus offerings, equity crowdfunding, private placements, and other corporate matters. That's a lot to handle. That's a lot to pack into one brain, Michael.
I know it. I know. It's all relevant to what some companies are, involved with today. Whether they're trying to go public, whether they're trying to stay private, they need to raise capital. With the Jobs Act that was passed a few years ago, the whole landscape really has changed in the way companies can, go out and raise capital.
I agree. There's so many different ways to do it now. Before it was this IPO or private placement. And now it's ICO, IPO, Reg A plus, Reg D, it's all the way down, crowdfunding, equity, non-equity. Come out with your own cryptocurrency. Tell me, how are these guys doing it today? What's the most effective?
Well, that's a very good question. First off, a lot of companies, if they're startups or if they're pre-revenue, early stage, they need seed capital. Usually that's anywhere from $100,000 to $500,000. The way companies do it now and the way I assist companies is through equity crowdfunding. That's a new regulation that became effective about 18 months ago. With equity crowdfunding, you put together what's called Form C. You file it with the SEC. You get the green light from the SEC. And then you upload all your offering documents to a SEC-approved funding platforms, such as microventures/funders. There's about 30 different equity platforms, and you have to use a platform. You can't use it. You can't go out and raise money yourself and have the calls come to you. The calls from investors have to go directly to the platform where a licensed broker-dealer answers questions and then closes out the financing. It's a very good tool for early-stage companies to raise that seed capital. In the past, they had to rely on friends and family. And most people really don't have friends and family that have deep pockets, or most people don't want to handle or get money from their friends and family because if you lose that money, then getting together at Thanksgiving and Christmas is kind of rough. So this is a tool, equity crowdfunding. That's one tool that's available right now.
Okay, what are the procedures for this process?
Well, first off, the client needs to usually engage a securities lawyer to fill out Form C that's provided by the SEC. That's almost like a prospectus, talking about the business model, the risks involved with it, the management team, etc. Once that prospectus is on file with the SEC, and there is no review or approval. Once it's filed, you kind of get a green light, a letter saying, go ahead and raise your money. Now, having said that, that's one phase, but the critical phase is marketing that offering to potential investors. And that's where a lot of companies fail to raise capital. Now you're allowed to do radio commercials, television, email blasts, social media, all types of advertising and marketing of your offering. That takes money. And typically, the cost is anywhere from $15,000 to $50,000 that a company should have set aside to cover the marketing. I know a lot of companies out there pay a lawyer to do the filing. They upload it to their offering documents to a platform, and they sit back and wait. They think the money's going to roll in. It doesn't.
No,
they need to get out and be proactive in advertising and marketing. But you have to be careful what you say. The SEC is very stringent about what you can say in your advertising when you're marketing it. And certain elements. Basically, all you have to say, all you can say is, we have a crowdfunding offering. Here's the link to the platform. And that's about all you can say. You can't discuss terms, conditions, and anything specifically about the offering.
Okay. All right. But you can talk about the product and talk or the service all you
Yes.
want.
Yes, you can talk about the company. You can talk about the product. You can, like I said, you can get on television and radio and email. You can brand your specific product um, and talk about it. And direct people to the link for the funding. But again, you can't talk about the terms and conditions of the actual offering that you're doing.
Okay. What about finders? Talk to me about those because that's a
So
part of the whole mosaic.
yeah, I'm glad you brought that. Is another good question. There is no such thing as a finder. I know for years and years, people have been using unlicensed so-called money finders. Your gardeners, guy you play golf with, whatever, to go out and here's my business plan, shop it around, and if you can raise me $1 million, I'll pay you 10% of what you raise. You can't do that. It's illegal. The only entity that can get a commission, a success-based compensation, is a licensed broker-dealer, period. There is no gray area. Lawyers can't take a fee, a percentage. Accountants cannot take a fee, a percentage, a success fee. Only licensed broker-dealers. And somehow, I've been in this business 25 years, and it's out there that all I have to do is hand my business plan out to a stranger, let them shop it around, and if they're successful, I'll pay them a commission. You just can't do it. You violate state security laws and federal security laws. But if you use equity crowdfunding, I mean, you still can't use a finder, but you can pay promotional fees to somebody to put a video together, to market it, but you're not paying them a percentage of the money raised. You're paying them a flat retainer, a marketing fee to direct investors to the platform. That is allowed by the SEC. But the other way around, like the finders thing, is just not legal. I know people do it. They get away with it, but they're just playing Russian roulette when they do it.
Mike, I think that in Texas there is a finder's license that you can get to participate with that without having to be a full blown broker dealer or a member of a broker dealer. Are you talking just about where you are or nationwide?
Well, generally it's nationwide. It's in every state, and usually the federal law with the SEC trumps the state law. However, Texas is kind of an unusual state. They may have, and I'm not giving legal advice here. I'm not familiar with each and every state, but in general, you have to be a licensed broker dealer if you're going to get a success fee. Now, if you're getting a retainer to look around for money that's not tied to the success, there's no problem with that. But if you're in the state that, and I know there's some states out there that don't have a regulation, but the federal law is real clear, very clear, that you cannot collect a success fee unless you're a licensed broker dealer.
Okay, let's take a break, Mike, and then come back on the other side and talk more about how to raise money, all right?
Sure, absolutely.
All right, we'll be right back with Michael Brette, and he is the president, CEO of VentureNet Capital Group, Inc., Small Cap Equity Advisors. We'll be right back. Welcome back to CEO Money. I'm Michael Yorba, your host. Thanks for joining us. All right, Mike Brette, President, CEO of VentureNet Capital Group, Small Cap Equity Advisors. All right, Michael, let's continue the conversation about raising capital for companies. Can you raise capital with a business plan, pitch deck, or business summaries? Let's work on that one.
The short answer is no. You need to have, and I know everybody tries that. I get probably 5 deals a day. Somebody sending me a business plan and a pitch deck and an executive summary. You can only raise capital if you have an SEC qualified offering, whether that's an equity crowdfunding that we discussed in the last segment, or whether it's a 506C private placement, or whether it's a Reg A plus offering. You need to follow state and federal security laws and have those documents. Now, a business plan is incorporated into those eventual documents. So when you do a private placement under 506C and you put together a PPM, part of that TPM would include the business model and the business plan. But you can't just go out with your business plan, present it to somebody, and have them write you a check. There are documents that have to go back and forth, legal documents, in order to legally accept the investment capital.
So not a simple equity letter, a letter stating, I will give you XYZ stock for your investment in our company under the terms that it's private, you can't sell it, it's restricted until, and we have first right of refusal, something simple, a simple equity letter?
No, that really, the documents we're talking about are risk disclosure documents.
Right.
So that when you put a PPM together, the reason the SEC came up with, under the security laws for PPM, is so that it protects both the issuer and the investor, because everything is disclosed, about the security being offered, the risk involved with the business. And that takes that disclosure, that risk disclosure, and the anti-fraud provisions of the securities laws are very complicated, and they can't really be explained in a 2 or 3 page letter to the satisfaction. Now, having said that, under Rule 506C, you can only approach and take investment capital from accredited investors. And I'll go into that in a little bit. But if you're taking money from accredited investors, there's a little bit different standard. You can use just a subscription document with risk disclosures in that, and that's typically maybe a 5 or 6 page document. But the downfall of something like that is if you're not really sure this person is accredited, and the standards have changed, you can no longer have the investor just sign a suitability questionnaire stating the fact that he's accredited. You have to hire a third-party verification firm to verify that person is accredited. They have to get bank statements, brokerage statements, a letter from their CPA, a letter from the attorney. There's a list that the SEC calls reasonable steps to verify that this person is telling you the truth when they're accredited. Now, if you end up taking money from somebody that is not accredited, then you violated security laws, and now you got a problem. So, it's not as simple as some people try to make it out to be, but again, it's not as complicated. You just need to follow, the correct steps.
Okay, I was under the impression that a REG A Plus allowed you to take investment from people who are not accredited. Yes,
you're correct. Under REG A Plus, you can. Under equity crowdfunding, you can take capital from accredited and non-accredited. Under REG A Plus, the same thing, accredited and non-accredited. But under Reg D 506C, which allows you to advertise and promote, if you're using that exemption for registration, you can only take capital from accredited investors.
What is there a 35-person rule anymore, or is that gone?
That's if you use the Reg D 504, but nobody uses that anymore because the main reason is you can't advertise and promote under Reg D 504. So you're stuck with the old rule of dealing with people you already know and have a substantial business relationship. And that's one of the reasons why the SEC passed this Jobs Act, which allows small businesses to advertise and promote, is because a lot of businesses didn't have a deep network that they could go to, so they allowed them to advertise. So there's really no benefit in doing a Reg D 504 because you can't advertise and promote the offering.
What about using the Jobs Act to raise capital?
Yeah, there's several methods. And the first, it's the equity crowdfunding. Then it's the 506C, and then what they stated the terms and conditions of Reg A Plus. It used to be you could raise up to $5 million. Now you can raise up to $50 million. There are 2 levels of a Reg A Plus. You have a Tier 1 and a Tier 2. Virtually nobody uses the Tier 1 because you have to. That limits you to a $20 million raise.
Right, and Tier 2 is 50. You're right.
And the Tier 2 is for $50 million, yes.
Got it. Michael, we've got to draw it to a close, but thanks for being a guest and clearing a lot of stuff up for us today.
Sure, I appreciate it.
My pleasure. Michael Brette, President, CEO, VentureNet Capital Group, small cap equity advisors. You'll find him on LinkedIn. Just go in there and do a search for Michael N. Brette, J.D.